In this case, Carbolic Smoke Ball Company made a product named Smoke Ball, which was formulated as a cure for several illnesses like influenza, high fever, coughs and colds, and so on and so forth, as advertised by the company. For any reason, the company guarantees that an individual who gets sick upon using the product will receive compensations of £100 according to terms and conditions as per mentioned by the company. Louisa Carlisle, as the plaintiff, claimed that she got sick after using their products according to the instructions mentioned, and she claimed the £100 as advertised. Nevertheless, Carbolic refused to remunerate the amount to the plaintiff.
The Court of Appeal came to the conclusion that the offer was essentially unilateral, and that its purpose was to create legal connection with the person who accepted the terms in exchange for £100. The Court of Appeal came to this result after reviewing the relevant offer. The court also determined that neither party needed to notify the other of their acceptance of the offer because it was unilateral in nature. The question of whether an offer may be made internationally if there is a possibility that it will be accepted as long as the prerequisites are met has now been taken up by the court. As a result, Mrs. Khalil was qualified to file a claim for £100. In addition, the plaintiff claimed that the advertisement itself constituted an offer that anybody would view it could accept. The court dismissed the defendant's appeal in line with the plaintiff's argument. According to the advertisement, if the offerer uses the smoke ball as directed but still contracted influenza, they will have to pay £100. To make it possible for the plaintiff to continue using the Carbolic smoke ball, they had to provide the consideration that was needed to be part of their contract.
For the case analysis, firstly, since the case is brought to the Court of Appeal, both the plaintiff and the defendant have been tried in the second highest court in their geographical area, which is the United Kingdom. It was a big case and also a lot of money was involved. Secondly, the implications of the ruling is that the judgment was right because the product promoted by Carbolic Smoke Ball Company was advertised to be able to prevent a plague during that time, which is the Russian flu. But the client contracted the disease even though she had bought the product from them. This case is guidance for judges because it demonstrates clearly of the offer and acceptance situation. It also demonstrates the difference between invitation to treat and offer and acceptance. It also transforms medical marketing as companies are now focusing more on product efficacy rather than the benefits because they fear the legal consequences that may arise from their actions. So it also improves medical law enforcement as regulatory organizations are now scrutinizing health-related marketing more closely through accountability and transparency. Lastly, how does it affect law in the United Kingdom? Generally, this case falls under contract law in United Kingdom, specifically unilateral contracts and the acceptance of offers given that there is explicit performance. This case has helped to shape future decisions and still influence contract law jurisprudence. Thank you.
For the reason part, the principal used in this case is the law of contract, which will be defined as an agreement enforceable by law between two or more parties that is binding legally between them with the presence of some elements, which are of an acceptance, considerations, intention to create legal relation, and legal capacity. In the case of Karil Carbolic Smoke Ball, the reason why the Court of Appeal rejected the defendant's claim that the advertisement was just a smokescreen. But the Court of Appeal dismissed this argument because the defendant has deposited €1,000 with the Alliance Bank just to verify the validity of the goods. Due to this, a reasonable reader of the advertisement will view the pledge to pay €100 as one that required careful consideration and that, given the circumstances, had really shown up and could result in a legally binding duty. As such, the advertisement functioned as an offer. So, the court didn't find an issue with the defendant's argument that the advertising had not been directed to any particular individuals since it had been published. In this particular case, the offer was made to all parties, including Mrs. Carril, who met the criteria specified in the advertisement. The court made the comparison to an offer of price, which may be taken by everyone who satisfies the requirement. Regarding the defendant's claim that Mrs. Carril should have notified them of her acceptance, the court again stated reward cases in its decision, holding that the Carbolic Small Ball Company could be understood as waiving the need to communicate acceptance based on the advertisement's wording. This was in response to the defendant's argument that Mrs. Carril should have informed them of her acceptance. The company could only have reasonably accepted to hear from customers who had used the smoke ball as instructed and then had the view. They could not have reasonably accepted that every client who purchased a smoke ball would get in contact with them. Overall, the court's ruling was based upon contract law principles pertaining to unilateral agreement, consideration, the intent to establish legal obligations, and the satisfaction of conditions. This case set the precedent that the advertisements can constitute unilateral contracts, and the advertisers are obligated to honor their agreements provided if the other part complies with the specified conditions.
In the history of contract law, the case of Carlo v. Carbolic Smoke Ball Company was an important event, questioning the legal weight of an advertising promise. At its core, there is a debate about the binding nature of advertising and compliance with its terms by consumers. Mrs. Carlo's pursuit of the promised £100 prize brings to light the complexities of offer, acceptance, and consideration in advertising-based agreements. Did she fulfill the conditions set by CSPC, and if so, was she entitled to the reward? The crux of the matter lies in the legal clarity of the advertisement distributed by CSPC. Was it a binding contract? Did Mrs. Carlo sufficiently fulfill her obligations as outlined in the widely disseminated advertisement? The case delves into the fundamental principles of contract law, dissecting the circumstances of offer, acceptance, and consideration within the realm of advertising. It underscores the importance of clear communication and intention in contractual agreements. Ultimately, the Carlo case serves as a touchstone in legal history, shaping the contours of contract law and illuminating the intricacies of consumer rights in the realm of advertising-based agreements.